Welcome back. The Public Procurement Act recently signed into law by President Cyril Ramaphosa has been labelled as unconstitutional by the Western Cape Premier, Alan Winde. The Act aims to create a unified procurement of all organs of state. Premier Winde has raised serious concerns about the Act, arguing that it undermines the autonomy of the provinces as well as municipalities in setting their own procurement policies. He believes that the processes followed in drafting the legislation was inadequate and has called for consultations to address these issues before the Act is implemented. For more on this, let's now speak to the Western Cape Finance MEC Deidre Baartman to discuss some of the concerns that they have with regards to the implications of the Act. Deidre, very good morning to you. Thank you so much for making time for us this morning, MEC. What's your concern around this particular Act in its current form?
Thank you so much for having me. The golden thread through this particular act is centralization and dealing with the autonomy of organs of state, such as those in provinces and local governments. The Act, for example, attempts to exempt procuring institutions from developing our own procurement systems, but we do not need exemption from National Treasury. The Constitution already empowers us to develop our own, as confirmed by court rulings. Further, the new Chapter 4 is substantially different. It deals with preferential procurement. It is substantially different to what went out on public participation and attempts to compel organs of state to adopt a preferential procurement policy. And in terms of the Constitution, it is National Treasury's job to lay a framework and not to write policy on our behalf. The Act further goes and prescribes onerous provisions in terms of preferential policy prescriptions, which previously have been declared invalid by the Constitutional Court. The Constitution, in terms of Section 217, provides that if an organ of state is to adopt a preferential procurement policy, that legislation must prescribe a framework within which our policies must be adopted. What this means is National Treasury cannot write policy for us, and it definitely cannot legislate it for us.
Yeah, but does the Act really say that this is what the policy is? If you read Chapter 5 on preferential procurement, it says, this is now Section 16, procuring institutions must develop and implement a procurement policy. So meaning that those institutions must develop their own procurement policies. This does not necessarily say that this is the policy.
Okay, I have the Act in front of me, and you're referring to Section 16
Yes.
of the Act. But Section 16 is not the only section in that chapter that deals with the matter. When you go further in terms of Section 17, it deals in with set-asides with preferential procurement. These set-asides, for example, in the 2017 Minister of Finance versus Agribusiness case, was declared invalid in terms of the 2017 regulations, which included set-asides and subcontracting. You then go further to Section 18, which deals with pre-qualification criteria for preferential procurement. You then go further to deal with Section 19, subcontracting as a condition of a bid. So when we read sections in a law, we have to read all of the sections in terms of the context of the particular law. So instead of actually putting a framework together for organs of state, what National Treasury is doing, it has gone to attempt to legislate what the Constitutional Court has already said it cannot do. And in terms of that centralization, in terms of the encroachment upon the autonomy of provinces and local municipalities, the Premier and myself have jointly thus written to the President and requested that he does not allow this act to go into implementation and that he consults provinces and local municipalities first, so that we are able to attempt to resolve the constitutional matters in this law.
Sure. Again, on that Section 16, do you agree that it doesn't say that this is what the policy is, but this is what is expected, and that policies the policies will flow from the procurement institutions following this particular, you say it's not a framework, but following this particular guidelines. Do you agree?
Okay, do you have Section 16 in front of you? Because
yes,
I do.
I have it, yes.
Okay.
Yeah.
So when you go to subsection 2, which is in part of Section 16,
yes.
do you see the provisions there speaking about set-asides?
The procurement policy of procuring institutions referred to in subsection 1A, setting aside bids in accordance with section 7.
You missed 3 words. You
Okay.
missed 3 words where it said must provide for. Must is a compulsory matter in law. May is discretionary. Now, when we go to the Constitution in section 217, the Constitution reads as follows. 217.1, when an organ of state in the national, provincial or local sphere of government or any other institution identified in national legislation contracts for goods and services. So in layman's terms, when we buy, sell and build stuff, it must do so in accordance with a system which is fair, equitable, transparent, competitive and cost effective. And there's various different court cases in terms of how the system must be balanced. Then subsection 2 says the subsection 1 does not prevent, okay, the words are does not prevent the organs of state or institutions referred to in that subsection from implementing a procurement policy. Again, the word preferential is not before the words procurement policy, providing for, and then it lists A and B, the respective matters that you can consider within that procurement policy. And then further it goes that if like national legislation must prescribe a framework within which the policy referred to in subsection 2 must be implemented. So National Treasury can prescribe a framework for us in which we are allowed to write our own policies. But National Treasury cannot attempt to do our own work for us or decide what that work will be.
Okay. Let me ask you about the role of, or rather the implications, as per your interpretation of this legislation, what this would mean for the province as well as the municipalities.
Currently, the regulations have not been drafted for this national legislation. So we've asked the president for it not to be implemented. If this act goes into implementation and regulations are written, part of the centralization within this act is the legislature has essentially delegated its legislative power away to the National Minister of Finance, as well as the Office of the Public Procurement Office in terms of drafting various different regulations. For example, in the set-asides provision of Section 17, which you didn't previously mention, no thresholds has been put into this particular section. So even if National Treasury did want to write policy on our behalf, which we contend they are not allowed to, the actual provisions are actually not clear about how it should be implemented. It will create confusion and uncertainty within the current procurement system. If this act was an attempt to try and consolidate and to provide clarity, it has not achieved that.
Yeah, so considering that that threshold isn't there, again, if you go back to the section that you're referring to now, section 17, specifically subsection 1A, a procuring institution must set aside a bid for a category of persons provided for in subsection 3 in accordance with the prescribed threshold and conditions. Is the Western Cape government against the idea of having legislation that says that you must set aside a bid category for underprivileged individuals or previously marginalized individuals?
No. So let me explain how procurement, because sometimes we get the different definitions incorrect. And it's usually something that is quite simple, actually, because it's very legal and technical wording. So let me just give you a little bit of context. Procurement is everything government buys, sells, and builds on behalf of residents. So that first and foremost must be based on value for money, because it is the people's money. And the people's money must be spent in the most efficient, effective, and economical manner. Preferential procurement is when government wants to include secondary goals that it wants to achieve over and above value for money. It is a discretionary matter. Despite it being a discretionary matter, the type of preference you allow could be for building more schools and hospitals. It could be for achieving climate change goals. It could be for energy security, for innovation. It could be for developing SMMEs or for nutrition, quite frankly. It does not have to be BBBE. Let me make this very clear. Preferential procurement and BBBE are two very distinct matters. South Africa needs to get its priorities straight. We are busy fighting about which tenderpreneur gets to eat more. Meanwhile, the middle and lower class income families are struggling to put food on the table. It is my view that the spirit of the constitutional provisions is to permit preferential procurement as a mechanism to remedy the impact of apartheid through empowerment without excluding any person or group of our population from participating in economic opportunities. You are able to achieve that without set-asides.
Yeah, so again, I'm asking this again. Is the Western Cape government against the idea of having a specific bid category that is set aside for marginalized groups and previously disadvantaged groups, considering, again, the constitution that you refer to also says that we as South Africans realize the injustices of the past, and now the question is, how do we then deal with the question of redress, as well as ensuring that we create equal opportunity, because that's what the constitution also speaks to, equal opportunity for participants in our economy?
Thank you so much. The criteria in Section 217 is actually equitable and not equal. But if you look at subsection 2 of Section 17 of the bill, it says there, because you mentioned the set-aside criteria, the minister must, subject to this subsection, prescribe targets for set-aside referred to in subsection 1. This goes clearly into policy drafting. Also, set-asides and bid categories are different matters. Set-asides is what you do when you're then saying that actually we're going to start excluding persons or groups of our population from participating in economic opportunities. Bid categories is how you deal with the different methods and types of procurement when you consider someone an SMME or a large organization, for example, whether someone, for example, has the capacity to do something, the ability to implement it. Those all go into things like bid categories, which is also something that goes into a procurement policy, which we are saying National Treasury cannot write on our behalf.
So MEC
no, we are not against empowering people and making sure that we redress the past. We are against the way National Treasury is going about it.
No, I'm saying specifically, are you against having a category, a bid category, being set aside for previously disadvantaged people? The Act refers here to subsection 3, provided for persons provided for in subsection 3. And what does the subsection say? Is it the list of people there? Black people, black women, black people with disabilities, military veterans, persons referred to of the paragraphs A to F within a geographical area, and then it goes, and the list goes on. So again, is the Western Cape government against the idea of having that specific category being legislated to say that now you must have a category that is set aside for these specific individuals that we've just listed? I'm not asking whether you're against transformation, but asking whether you're against having such a category.
Okay, but you're asking me two different things. You're asking set-asides in terms of bid categories, which are different things.
So the category, yeah.
We are not against bid categories, we are against set-asides. This provision deals with set-asides, subsection 3, and you forgot to say 2 in terms of subsection 1, but that's okay, which is where the minister has to put regulations in charge for us. That deals with set-asides. There are different matters dealing with bid categories. When it comes to set-asides as a whole, which was declared invalid in a constitutional court case with the 2017 preferential procurement regulations in the Minister of Finance versus Agribusiness case, it was considered invalid and unconstitutional for the National Treasury to be compelling or to dictate to organs of state what our policy needs to be. In terms of bid categories, you can't be against a bid category because you must write into what your different bid categories is going to be in a policy. So I'm not too sure what you're asking me in terms of the bid category, but in terms of set-asides, we are against set-asides.
Okay. Are you taking this matter to the court?
We are awaiting the reply from the president. And to my knowledge, he has not responded yet. And we want the president to consult the provinces and the municipalities in terms of the way forward on this bill so that we are able to resolve some of these constitutional matters. Should it come to it, we would consider legal action.
Thank you so much for your time. That is the MEC for Finance in the Western Cape, Deidre Baartman, on why they believe that the Public Procurement Act, which has been signed by the President, is unconstitutional.